Supreme Court temporarily freezes order requiring Trump administration to provide full SNAP payments to millions of Americans. Washington Supreme Court Justice Ketanji Brown Jackson on Friday froze for now a lower court order that required the Trump administration to swiftly provide full federal food benefit to roughly 42 million Americans. The order from Jackson is temporary. She said it will give a federal appeals court more time to consider whether to provide the Trump administration with longer emergency relief while an appeal in the dispute over payments for the Supplemental Nutritional Assistance Program moves forward. The Supreme Court late-stage intervention came as the Trump administration closed in on the end-of-day deadline set by a district court judge Thursday to cover in full food assistance for November and use roughly $4 billion for other nutritional programs to do so. The U.S. Court of Appeals for the First Circuit had temporarily left in place the lower court decision, after which the Justice Department sought emergency relief from the Supreme Court. Jackson wrote in a brief order that her administrative stay will facilitate the First Circuit expeditious resolution of the Trump administration request for the longer pass of the district court decision. She said the appeal court should resolve the pending motion with dispatch. In its emergency appeal to the Supreme Court, the Trump administration said it has already exhausted the entirety of a more than $5 billion contingency reserve, which was enough to provide only partial food assistance payment for the month. It warned that the additional $4 billion needed to cover the full allotment for low-income Americans would require it to dip into a fund designed for child nutrition programs. Going ahead, pulling billions of dollars from the child nutrition programs would jeopardize those programs' ability to fully operate this year, putting at risk critical food assistance initiatives relied upon by millions of children every day, and rating a program that Congress did not fund to instead extend one that Congress has not funded. Solicitor General John Stewart wrote in a Supreme Court filing. A USDA official notified states earlier Friday that it was working to comply with the district court order to provide in full the food benefit to Americans enrolled in SNAP. The Supreme Court decision is the latest development in the legal battle over SNAP benefit that has unfolded over the past several days. These payments are used by the recipient to purchase groceries, but the USDA said late last month that assistance for November would not go out because of the ongoing government shutdown. A group of cities and non-profit organizations sued the USDA last week amid rising concern that the lapse in the payments would leave millions of low-income Americans hungry. U.S. District Judge John McConnell, who is overseeing the case, then ordered the Trump administration to dip into a contingency fund to provide food aid to the roughly 42 million Americans enrolled in the program for November. The administration told the court Monday that it would comply with that order, but said there was only enough reserve money to provide partial SNAP benefit. The USDA said states the information needed to calculate the reduced payment to eligible Americans on Tuesday, but it warned it would be weeks before the assistance reached a recipient. The plaintiffs then asked McConnell for additional relief that would require the Trump administration to make full SNAP payments immediately. In a decision Thursday, McConnell accused the government of undermining the intent and effectiveness of his earlier order to distribute the aid to SNAP beneficiaries as soon as possible. He pointed to a social media post from President Trump on Tuesday in which the president said benefit would be given only when the radical left Democrat upon a government which they can easily do and do not before.